Hi, everyone. My name is Yasmin Yavar. I'm a senior staff attorney with CILA, the Children's Immigration Law Academy, and I'm so happy today to be recording with Mary and Trina from the National Immigration Litigation Alliance, or NILA, this training, which is another in our series on appellate and litigation strategy, this one focused on administrative claims under the Federal Tort Claims Act. So a little bit about our partnership with NILA. We provide trainings, resources, and technical assistance for folks in Texas related to appellate and litigation practice through this partnership, with some emphasis on matters originating within the Fifth Circuit. So a lot of the trainings are broadly applicable and you will find them beneficial, but for some of them, there is a Fifth Circuit focus. Posted trainings that you can already find on our website under the trainings tab and appellate and litigation strategy tab are listed here. They are trainings that cover everything from the basics of federal court practice to winning at the ABA to habeas petitions and mandamus petitions. Most recently, we had a live training with NILA on petitions for review and judicial stays of removal to the Fifth Circuit Court of Appeals. It was also recorded, as are all of these trainings, and you can find it on our website. Again, the partnership entails trainings, both live and recorded ones like this one, resources like practice advisories and templates, and also for folks in Texas, technical assistance on cases, as well as legal writing, technical assistance if you need it. You can just reach out to CILA, and if it's an appellate and litigation strategy question, we will connect you with the folks at NILA. And with that, I will turn it over to Mary and Trina, who will present to you on administrative claims under the FTCA.
Thanks, Yasmin, and hi, everyone. It's nice to be with you today, and want to thank you for joining a webinar that is on a topic that is not traditionally thought of as the immigration law or immigration practitioners doing. But we believe that we think that claims under the Federal Tort Claims Act can add a lot to your practice. And I want to start by saying that they are not rocket science. And what we're going to be talking about today is relatively straightforward stuff. And so thank you for listening, learning a little bit about it, and just know that NILA, through our Strategic Assistance Program with CILA, is available to you to answer questions that you may have if you're thinking about getting into bringing a claim under the Tort Claims Act. So that is the name of the statute that we're talking about, and the law is on your slide, the 28 U.S.C. 1346B and the governing regulations. And it is about bringing tort claims against the United States for misconduct and abuse by immigration officers, broadly speaking. And the standards of proof involved in this type of claim are substantially less than what is required if you're trying to prove a constitutional violation. And so we're going to dust off a little bit of tort law as we go forward in this presentation. But just remember, torts is a subject that we all took. You don't have to be tort experts to do this. You just have to know what happened in your client's case. And so without further ado, we're going to be talking about the mechanics and how to file and where to file. But let's first cover some basics about the statute and what it does. So I'll turn it over to Mary.
Great, thank you, Trina. So the FTCA, or the Federal Tort Claims Act, is essentially provides an avenue for an individual who's been harmed, as Trina indicated, to get money damages for harm by a U.S. official or employee where that harm was a tort. And there are two stages for any FTCA case, and one is the administrative claims process, which we're going to talk about in depth today. And then following the administrative process, an individual can choose to go into federal court if they're denied at the administrative level. And we won't go into any detail at that with respect to federal court actions. We'll sort of cover it generally, but just one of the basics of an FTCA's claim is that if you do go into federal court, there is no jury trial. It's a judge trial only. So the judge makes the decision about liability as well as about monetary damages. So the FTCA itself provides only for monetary damages. You cannot get, and they're compensatory damages. You cannot get punitive damages under the FTCA, and you also cannot get injunctive relief from the court. But frequently, I wouldn't say frequently, but it has happened that in settlement discussions with the government, and the government may agree to provide some type of immigration relief to your client. And frequently that is as important to clients as the money is. As many of you, I'm sure, realize, getting some kind of legal status is really the highest priority for so many people. And so that's something to keep in mind as you think about whether to bring a FTCA administrative claim. Under the Act, an individual who succeeds with a FTCA case, either settlement or succeeds by getting a judgment from a court, is entitled, their attorney, there's a provision that indicates their attorney is entitled to get to ask for a portion of the settlement as a contingent attorney fee. And that portion is limited to 20% if the case is settled at the administrative process, and 25% if the case is either settled after a lawsuit is filed or if a court makes a decision, a favorable decision after the lawsuit. So there's a cap on the amount of attorney fees that an attorney can claim from the settlement that the client receives. But so that is some protection for the client. For nonprofit attorneys, that does mean that these cases are fee generating, and it is possible to get some attorney's fees if it's successful. And so that's something that to also keep in mind. Next slide, please.
Thanks, Mary. And I guess I would just add to that there are so few FTCA claims that ever go to a judge trial that we don't want you to think that the fact that we're giving you the basics overview and telling you about that means that if you take a claim under the statute, you're going to be going to trial. Many of us have been doing these types of claims for years and have not actually gone to trial. So a quick refresher on torts for those of you who are thinking back to your first year of law school. The FTCA allows for compensation for two broad groups of torts. The first is negligent tort, right? So that's making you think of duty and breach of duty and causation and all of that stuff. There are negligent and infliction of emotional distress. There's emotional distress claims. There are wrongful deportation claims. For example, when somebody is deported in violation of an automatic stay, or that happened by operation of law, or by in violation of a court's stay order. And there are also claims involving medical care and the deprivation of adequate medical care. So those are the negligent type torts. And then there are intentional torts. But the caveat here is that those intentional torts, in order to be actionable under the FTCA, must have been committed by investigative or law enforcement officers. So those torts are things like assault, battery, false imprisonment, false arrest, abuse of process, malicious prosecution. Those are the types of intentional torts. But who is an investigative or law enforcement officer? Well, for the most part, It's any officer that's empowered by law to execute searches, seize evidence, or make arrests. But what does that mean in the immigration context? It simply means that most DHS officers that are interacting with our clients, including CBP, ICE, and USCIS, the FBI, and Marshal's officers, will meet the definition of a law enforcement officer for purposes of this statute. One little word of caution, however, that if you're talking about actions by these investigative or law enforcement officers, and you are trying to bring a claim for things like libel, slander, misrepresentation, deceit, or interference with contract rights, the FTCA, the law enforcement proviso, we call it, will prohibit that type of claim. But for the most part, the types of claims that we see in the immigration context involve things like false imprisonment, right? Detention of somebody who is a US citizen, for example. Wrongful deportation, we see a lot of that. Negligence, as we all know, there are a lot of negligence claims, but also intentional infliction of emotional distress by ICE officers or CBP officers saying horrible things to our clients. And occasionally we will see, I mean, I shouldn't say occasionally, we also see assault and battery, right? So when there's some type of physical altercation, that will amount to battery, but assault doesn't actually require the physical touching. That is more intimidation and threats and things of that nature. So all of that to say is these are the types of activities that can form the basis of an administrative FTCA claim. You don't actually need to flesh out what exactly all the torts are at this stage, at this first stage of the process that this webinar is addressing, but it is helpful to look at your state law and familiarize yourself with what are the elements of these torts as you're thinking through putting together your tort claim package. Okay. How about we move to the next slide?
So let's talk for a minute about why you might want to file an administrative FTCA claim for your client. And the first kind of basic reason is that the administrative claim is a prerequisite to filing any lawsuit. And we're going to talk a little bit more about that later, but if the client is interested in pursuing the damages case all the way, he or she has to file. It's just a mandatory requirement to file the administrative claim first. But there are also other benefits because an administrative claim can be settled favorably. And if it is, then your client is going to get some compensation, some money damages. They may be able to get through the settlement process, as I mentioned before. They may be able to get some kind of immigration relief. It's something that has happened and that you can certainly negotiate with the government on in a settlement process. And then there's some less tangible things. It really is a very strong mechanism to hold the government and government actors, government officials and agents accountable for their conduct. And it's a way to try in holding them accountable and in making them pay money for misconduct and for abuse. It's a way to try to deter future misconduct and abusive action by agents. You know, the government having to shell out money is probably one of the biggest ways in which individuals can try to impact future abuse by either those same agents. Even though the agents themselves don't pay, there can, you know, the government, it's the US government that is sued in this case and is responsible for paying any damages, not the individual agent. But the agent, there may be other repercussions for that agent, and it may deter future misconduct. And then finally, we've already talked about there's a potential for some attorney's fees. So I'm going to turn it back to Trina now. Next slide.
Thanks, Mary. We wanted to present an overview of what we're talking about here today, and put in your mind that FTCA claims are a two-step process. The first step is what we're covering today. We're talking about the administrative claim. Mary's going to talk a little bit about exhaustion, but that is basically putting the agency on notice what happened and asking for an amount of money for what happened, for the incident. And that's what we're talking about today, putting the agency on notice, and that's called the administrative claim. It's basically giving them an opportunity to do something before you go running into federal court. And very importantly, you have to do this first step before you can go into federal court, which is the step 2 of the process. It's going to the district court and filing a complaint. And we'll touch very briefly on that at the end of the webinar, but that's not what this webinar is about. This webinar is about getting immigration attorneys who have these clients who see these injustices to feel comfortable filing an administrative claim in order to do, to give their client more options and perhaps compensation. So really importantly, you can't get to step 2 without going to step 1, and that is why it's a two-step process. I want to just briefly say that you could agree to represent a client only in step 1, right? You can agree to a limited representation agreement that says, hey, I will file your complaint before the agency, and that is what our agreement is going to be about. Now, if the claim is denied or constructively denied, and we'll talk about what that means later, you should do right by the client by giving the client proper notice of the denial and telling the client what his or her or their next steps will be. However, the fact that you might not feel comfortable taking the case to district court shouldn't hold you back from doing this initial stage, this initial complaint, because quite frankly, it could get resolved at step 1. Not all cases go to step 2. And like I said, giving people the option is just something that you can do for them. And it's really, really not rocket science. So let's move to the next slide.
Thank you. So there is an exhaustion requirement, as we've talked about already. The FTCA claim cannot be litigated in federal court unless an administrative claim has first been filed with the relevant agency, and that's 28 USC section 2675A. And there's a deadline for filing that administrative claim, and that deadline is 2 years from the date of the claim accruing. And the site is there, 28 USC section 2401B. But significantly, that deadline is not a jurisdictional requirement. The Supreme Court, in a case called United States v. Kwai Fun Wong, found that it was not jurisdictional, and therefore it could be equitably tolled, which means that if an individual is able to demonstrate exceptional circumstances for having missed the 2-year deadline, and if they demonstrated due diligence upon learning that there was a deadline for filing the, or that they had a right to claim, they exercise due diligence at that point in time, then they may be entitled to have the 2-year deadline waived. I would really encourage, obviously, the waiver using equitable tolling is going to be not the routine, normal way. You're going to try to file within the 2 years. I would encourage anybody who does run into a case in which the deadline has been missed to give us a call and talk to us, as we can provide technical assistance with respect to how to make out an equitable tolling claim and what the strength of that claim might be in a particular case. Trina, I'll turn it back to you.
Thanks, Mary. So now that we've talked about this fact that you have to exhaust by filing this administrative claim, and we've talked about this lingo of administrative claim, let's talk a little bit about what actually is in an administrative claim. What are you filing? And I'm going to start this part of the presentation by saying that CILA and NILA have put out sample materials. And so a lot of the stuff that we're talking about is available in the sample packet, and you'll be able to see in more detail what a sample will look like when you're putting your claim together. So the first thing is a cover letter, and that should be no surprise. We suggest doing that. It's not absolutely required, but it would have simply who the claim is going to. It would say that you're representing the claimant, and we sometimes put in language that reserves the client's right to confidentiality or privacy with respect to the claim. And all of that is in our sample cover letter that is in that CILA NILA packet on our websites. In addition to that, you're sending it to an agency, and we're going to talk about where to file momentarily, but our packet also contains addresses where you would send the claim. So that address section of the cover letter, the packet has those common addresses right there for you. You also have to attach proof that you, as the attorney, are authorized to file the claim. And Mary's going to talk a bit more about that on the next slide. There is a sample claim authorization form in that packet of materials. And basically it says that the person authorizes you, the attorney, or your organization to bring this claim on their behalf. And Mary will talk about this, more detail, but parents can bring claims on behalf of minors as well. And others can as well. So I'll leave that to Mary on the next slide. The next thing that you have to do is you have to put the agency on notice of what happened, right? The two big requirements to FTCA claims is you have to provide some notification of the incident, and you have to provide how much money you're seeking for this incident. And there's two ways to do that notification. The first is what we call Form SF95, which SF just stands for Standard Form 95. You can Google it, or you can write a letter and you can explain what happened, and you can say, and I'm requesting $100,000 in damages. We sort of suggest that you use the SF95 because by using that form, you can be sure that you have provided all the information that the agency might need to assess the claim. SF95 has some additional questions that aren't necessarily super relevant to immigration FTCA claims, and we have a guide on how to fill out that form in the packet that you can look at if you're like, I'm not sure, my client doesn't carry insurance liability coverage. Does the person need to? How should I answer that question that's on the form? Just take a look at our guide, right? Just write not applicable or no, whatever the case may be, because the form is helpful, but sometimes it asks questions that aren't necessarily related to immigration type FTCA claims. So either one, the form or a letter, your pick, you're just putting the agency on notice of what happened. Importantly, if you use the form, it does have a space for a sum certain for how much money you're asking for. And so you would put that down on the form. If you're doing a letter, you'll have to include that in the letter. Very, very important. If you are representing a family or more than one person, every claimant must have his, her, or their own form SF95. Or if you're doing a letter, they must have their own letter alleging what happened. And so many times it's much easier to do a SF95. There's not a lot of space on that form, so you can put C attachment, and then you can fill out the attachment with more detail, and you can use that same attachment for every claimant. sometimes when you're explaining what happened, you have documents in your possession that corroborate what happened. So, for example, if somebody was deported in violation of a stay, you could attach as an exhibit the proof that there was a stay in place. And if you're saying somebody has PTSD as a result of the horrendous experience they had in immigration custody or whatever the case may be, and you happen to have a medical report that attests to that, you could attach that. So exhibits and supporting exhibits that corroborate what happened or the harm that the person experienced are optional, and you can include them. And if you are claiming things like wrongful deportation and damages, and the person was out of the country and they had to take a bus to the border to get back in and all this stuff, if that person has those receipts of out-of-pocket damages that they spent, you could attach those. But again, it's not critical. The two critical things that are necessary, again, is the written notification and the sum certain. And that all comes together to be your packet of what you file. So I think we'll move to the next slide.
Thank you. So as Trina indicated, we're going to talk about the claim authorization. And this requirement is set out in a regulation, 8 CFR 14.2a, that talks about when a claim is deemed to be presented to the agency. And in addition to the agency receipt of the SF-95 or written notification with a sum certain. And note there that it's the receipt date, not the mailing date, that matters. But in addition, that form, there has to be a signature by the claimant or by his or her duly authorized agent or legal representative. And in addition to that signature by one of those people, if it's the duly authorized agent or legal representative, then it needs to include the title or the legal capacity of the person signing the form, and it needs to be have some evidence attached that demonstrates his or her authority to present the claim on behalf of the individual. Something that demonstrates that the person signing is authorized to act as the agent, as the is the parent, is the guardian, or other representative. So it's a little vague as to exactly what proof is required. And we did a little research on it and discovered that there are cases that discuss it. There are only a few of these cases that actually discuss it, and they're not all consistent. But it appears to us that possible signatories might include a child over 14. And the reason we say that is because the DHS itself accepts signatures by children over 14. And so they, in any application form, their rules indicate, and the G28, the rules for signing for an attorney to file a G28 talk about the child. If they're over 14, they can sign that form or any other form on their own behalf. And so that's a good argument to make that that in the comparable situation of an FTCA claim, a child over 14 should be able to sign. It may be possible that an ORR sponsor would be able to sign on behalf of the child, not the OOR employee, him or herself, because that person is a government employee, but the sponsor may be able to. Officially appointed guardians absolutely can. You'll need to attach something to demonstrate that this really is, that this person has been appointed as a guardian. And then lawyers can sign. you'll note in the language of the regulation, it talks about the legal representative. So a lawyer can sign with evidence of representation, and that evidence might be possible to attach a G28 or an E27 or 28 to demonstrate that there is that the attorney actually is representing this child. Questions about any of this, if you run into problems, if you have a young child and you're trying to figure out what to do with respect to signing, give us a call. We can absolutely help with technical assistance on this because it can get a little tricky, and we would want to make sure that you are preserving the claim by doing the most you can to meet this claim authorization requirement. The other thing to note with respect to this is that the individual, that your client, does not have to be in the United States to file a claim. Next slide.
Thanks, Mary. That's super helpful. And I guess on this piece of it as well, notification of incident, which is what I'll be talking about. You should also feel free to give us a call if you want us to look at how you wrote up the incident. Because when you're doing a FTCA claim, you want to be very factual in your recitation of what happened. And it is not an opinion type piece that you are writing. I've already talked about why it's preferable to use that standard Form 95. And then just include an attachment to that form, just simply because you'll be sure to be providing the agency with all the information that it needs. But there's going to be a place for a description of the incident. And on your slide here, you have two decisions from the Fifth Circuit, one from the Fifth Circuit and one from the Ninth Circuit, that stand for this general concept that we've been talking about. The Fifth Circuit says that the notification has to sufficiently enable the agency thoroughly to investigate its potential liability and conduct settlement negotiations with the claimant. And the Ninth Circuit says you have to provide a general description of the time, place, cause, and general nature of the injury and the amount of compensation demanded. And so all of this goes to, you sort of need to explain the who, what, when, where, and why of what happened to your client. And sometimes when we are doing an FTCA claim, we will assume that the reader doesn't know as much about immigration law as we do. So we include a little bit of a legal background if the claim is dependent on some type of legal background. If your claim is about somebody who was battered and physically abused, well, that doesn't require any kind of further explanation, right? Because that's sort of common sense. Immigration officers are not supposed to beat people up. But if you are trying to make out a claim that, for example, we have a case like this in our office, that a person was wrongfully deported because they were deported to a third country after they won withholding from a different country. And they weren't put on notice of that deportation to the third country. And they actually had a fear of deportation to the third country. In that situation, you might want to put a little background about, hey, what's going on here? Like, what is withholding? What does it mean to be deported to a third country? Why does ICE have an obligation to notify the person? So that's the kind of claim that you might want to provide some background on. But as I said, background is not absolutely required. It's not necessary for every claim. A lot of these claims and how you notify the agency of the incident are going to be on a case-by-case basis. And that's where I think we can help brainstorm with you what might be the most helpful way to convey what happened to your client. But just sort of think about the who, what, when, where, and why. And when you're providing your notification, they're answering those questions on the SF-95. And we've also included in that sample packet of materials a sample attachment of how you might write up some of this information. Okay, so let's move on now to the next slide. Mary?
Okay, so we talked before about the second essential requirement of any kind of narrative or discussion of the case on an SF-95 or in a letter is that you have to state a sum certain. Whatever you state in the administrative claim caps the amount that can be awarded in a lawsuit. And so you want to be careful to make sure that you aim high enough with respect to the administrative claim, that you value it high enough to avoid a low cap on your client's recovery. That cap has to be stated, and is the only exceptions to it being the cap for further litigation, in federal court, is if new evidence reveals damages that were not reasonably discoverable at the time that the administrative claim was filed, or if there's a demonstration of some facts that happened after the filing of the administrative claim that relate to the amount of recovery. So, for example, if it was a medical case and after the filing of the claim, the claimant's situation really deteriorated terribly, or something happened as a result medically that was not expected, then that might justify a different amount. It might justify a later intervention to come in and raise the amount being claimed. But those are very rare exceptions. So when you're doing the claim, you really need to expect that whatever you put on the claim form is the amount that your client ultimately, the cap on the amount that your client ultimately will be able to receive from any kind of award, whether it's through a settlement at the claim claim stage, or whether it's in federal court before a district court judge.
And I think, Mary, that adjudicators generally understand this cap requirement. And so when they see high amounts, they also know that you are factoring in the fact that there might be some smoking gun that you're not aware of. So you've added that amount to be high. Should we move on to the next slide? Okay. So let's talk about where to file. In straightforward cases, it'll be readily apparent. If ICE or CBP was the acting agency, then okay, the claim's got to go to one of those agencies, or both perhaps. The general rule is you file with the agency who employed the officers that give rise to the claim. And I recognize that sometimes multiple different agency officers are involved. And so, there's going to be a claim that'll be filed with more than one agency. That's fine. If that happens, one of the agencies will designate a lead agency after the claim is received, and that is set by regulation at 8 CFR 14.2b. That allows for the designation of a lead agency, and that agency will become your point of contact for the entirety of the admin stage and for the negotiations. So that'll happen. I also want to make people aware that if the claim is filed with the wrong agency, there is an obligation on agencies to transfer the claim to the appropriate agency. But in that situation, the claim is presented on the date that the appropriate agency receives it. And so it's important, as Mary was talking about that statute of limitations, maybe don't push it up to if you're not sure which agency was involved, try not to file so close to the end of the statute of limitation period, just in case the agency you file with finds that they're not the appropriate agency and they're forced to transfer it to a different agency. That also is in the regulations at 8 CFR 14.2 B. So that information is there. One thing that we do is we err on the side of sending the claim to multiple entities to ensure compliance with the statute of limitations. And so if it's a DHS agency, we're always sending it by regulation is required to send it to the Office of General Counsel for DHS. And we also will send it to the General Counsel for the agency that employs the offending officers, right? You can, if ICE committed the tort, you want to send it to ICE, but you also want to send it to the DHS Office of General Counsel. Now, I will say that some of these agencies have email addresses available where you can send a courtesy copy of complaints, and that comes up in the context of courtesy copies of federal court complaints. Filing by email is not a replacement or a substitute for sending the claim by mail in a form that can be tracked. So overnight mail, certified mail, registered mail, because you need to have proof of compliance with the 2-year statute of limitations. And so while it's fine to send a courtesy copy to the agency by email, do not forego sending a hard copy of the complaint and tracking that hard copy. So you have proof that you comply with that 2-year statute of limitations, because we know that the agency loses things. And Mary and I are involved in some cases where the agency didn't have proof of, didn't think they received it within the 2-year statute of limitations, but in fact they did. And the attorneys were able to prove that because they had tracked the package and were able to show they complied with the 2-year statute of limitations. So that's very important. The other thing I'd say is that if you're dealing with medical care claims, those are a little more nuanced, I'd say. And if the medical care provider was employed by the U.S. Public Health Service, then you are obligated to send the complaint to the Department of Health and Human Services. And so there's a little bit of a requirement that you sort of know or have a sense of what entity provided the medical care, so you know where to direct your claim. And that's all I'll say about that. But again, I'll just offer to say that we're available to talk about those on a case-by-case basis. And last but not least, when we're talking about sending complaints to ICE, CBP, ORR, Department of Health and Human Services, DHS, all of those service addresses are available in the FTCA packet that's on the CILA and NILA websites.
Okay, next slide. So what happens after the claim is filed? The first thing that should happen is that you should receive some kind of acknowledgement of receipt of the claim by the agency. But in our experience and in the experience of attorneys we work with, that does not always happen. It certainly doesn't happen necessarily with any timeliness. The agency could receive the complaint and then take weeks to notify you that it received it. And sometimes you may not get any notice at all. And so you may want to follow up with the agency. But, you know, as Trina said, if you have tracked the however you mailed it and have some proof of the receipt of the packet by the agency, then you're covered with respect to showing that you've satisfied the 2-year deadline. But once the packet is received, then there's some other time periods that are triggered. And the first is the agency doesn't actually have any deadline by which it has to decide a claim, but it does have this 6-month period in which to review and decide the claim that during which an individual cannot file the lawsuit. So for that first month, 6 months after receipt, the individual is in a holding pattern and just sort of has to wait to see if the agency does anything with it before making a decision whether to file a lawsuit or not. So that gives that agency a little room to make a decision before the case might go on to the federal court. If the agency, then there's a second 6-month deadline that comes into play. And that happens either when the agency denies the claim, whether it's within the 6 months or after, if you've waited. If the agency denies it, then the individual has 6 months within which to file a lawsuit. And so that's a second statute of limitations period. Again, like the earlier statute of limitations, it's not jurisdictional, so it can be equitably told, but that's one that you really want to watch and make sure that you don't miss it. Often the agency does not act within 6 months, and it could take a very long time for the agency to make a decision. Any time after that 6 month, that initial period of 6 months from when the claim was filed, if the agency has not yet ruled on the claim, then the individual has the option of going into court, and they have the option of essentially saying, because 6 months have passed, because the agency received the complaint on such and such a date, 6 months have passed since that date, and we've received no decision, this claim has to be treated as if it were constructively denied. And therefore, the administrative process is considered exhausted and the individual can go forward and file a complaint. So you can wait to 6 months. If no decision is made, immediately file after that 6 month period, or you can wait 8 months, 10 months, a year. You can give the agency more time, and if no decision is made, then choose to file. But remember that if a decision has been made at any point, then that triggers a 6 month deadline by which you have to appeal, you have to file the complaint in federal court. So I know that's very confusing. Call us if you have questions, or we also have a practice advisory, and it's set out in the practice advisory, and we'll give you the information about the practice advisory in this future slide.
Thanks, Mary. And because we know that this is confusing, this is one of the things that in prior presentations we get a lot of questions about. Mary just talked about the law, but we also wanted to have this second slide, which is a little bit repetitive, but lays it out from a practical point of view, we think. So after the admin claim is received, right, we just want to run through again what might happen. You've put together this packet, right? And the agency could receive it and then they decide that they need more evidence. And so they could ask you for further evidence of harm to the person, or they could say, well, you said that they had to spend this much money on a lawyer to remedy this injustice, and you're claiming recovery for that lawyer's fees. Can you provide us proof that they paid the lawyer? A whole bunch of different things. They could also say, do you have any psychological reports showing that your client has been traumatized by what happened? They can go ahead and ask for that evidence. You don't have to provide the evidence, and there may be strategic reasons to provide it or to not provide it. And again, case by case, right? And you might, you might want to provide it because you might say, well, my client doesn't ever want to litigate this case in federal court, so I'm going to just give them whatever they're asking for because we're going to try to settle this at the admin stage. But you might say, well, I'm going to hold off on this piece of information. I don't want to make my client go pay for a psychological evaluation at this stage. They don't have money. And if this case goes to federal court, we would pay, at that stage. lots of different factors to go into how to respond to a request for more evidence. One thing I would like to say, and that my general approach is, after I file the claim, I wait for about 2, 3, 4 months and hope that I get assigned a point of contact. If not, I try to hunt down a point of contact, and then I give them a call. And it's just an attorney that works for the agency. And I say, hey, I understand you're the point of contact. I want to talk to you about this case. I hope we can get it settled at the administrative stage. I want to talk through any issues or concerns that you might have. How could I potentially provide you information that could be helpful? And one of the things that they're looking to do is to see whether other people have settled for the amount of money you're asking for. And so sometimes I offer to send comps, we call them comparable cases, that have settled for around the ballpark of what we're asking for, whether it be immigration relief or a monetary amount. So that's one thing that you also can do. You can open up negotiations. You don't have to wait for the agency to do that. The agency may read the claim and come back with a settlement offer. That would be great. It shows that your claim is strong and that the agency wants to make this go away. All's good and well. Remember your ethics. If you get a settlement offer, you have to take that offer to your client. But you're also having the option to do a counteroffer. So that doesn't mean just because they offered you something, you have to accept it. You've got the option for a counteroffer. Now, going back to what Mary was talking about, it is entirely possible that the agency may do nothing, but they just sit on the complaint, the admin claim. And then again, if there's no response within a 6-month period, you can treat it as a constructive denial and you can go guns a-blazing into district court if that is what your client wants and if you're geared up for litigation. You can also do nothing. You can wait for the agency to act, or you can engage with the agency. But just because 6 months have gone by and nothing has happened, that doesn't mean that you have to go to federal court. You can wait, and maybe the agency gives you a decision a year or 2 years after you filed. And at that point, the clock to go to federal court would start ticking. But there's absolutely no obligation for you to do anything, to go running into federal court if for some reason you or your client are not prepared to do that. Finally, as Mary mentioned, the agency may deny the claim. A denial basically is a formal letter from the agency. And once you get that formal denial, that is when the 6-month clock starts ticking for you to have to go to federal court if you're going to pursue the claim. And then as you see, there's a practice pointer on your slide, which is, this is if you have a client that is seriously interested in settling and is a little bit shy about going to district court and everything that district court litigation entails, it is that type of case where you are going to want to reach out to agency counsel and start a negotiation process. Say, hey, what do you see that's strong in the claim? What do you see that's weak in the claim? How can I provide you any additional information? I think we can get this done. Let's work together. I want to work with you as your partner. And those conversations can be appreciated by agency counsel. They might not give you everything you want or the offer that you want, but you will be doing everything you can for your client in order to advocate on his, her, or their behalf for the claim. Okay, let's move to the next slide.
Thanks, Trina. So, for those of us who are not full-time tort lawyers, it's sometimes very difficult to figure out how do you value an injury to a client. And so I want to say it right at the get-go again, that if you have questions about that and would like to brainstorm about it, give us a call. We do have some resources available that might help with determining what is a reasonable amount to both to set as the sum certain that we talked about earlier, and then to think about in terms of any settlement offer that may be made to your client. But let's say you have the government, you've been in touch with the government attorney and an offer has been made by the United States to settle the claim, what happens then? What are the considerations that go into play at that point? And first and foremost is that any decision about settlement is your client's, and you have to take all settlement offers to your client and explain them to the client in a way that the client understands the pros and cons of the offer and what it would mean to accept it in terms of waiving any future claim to injury related to the event, and what it would mean to deny it, including, for example, going into federal court that might result in a greater award, could also result in a lesser award though. And so you have to sort of walk the client through all of those possibilities to help them make an informed decision about the settlement offer that's been made. The client may ask for your recommendation as to whether or not to accept a settlement, and you absolutely can make a recommendation, but you should make clear that it's only a recommendation and that ultimately it's your client's decision, and sort of help them figure out the factors that they should be thinking about when they make that decision. You should keep, as negotiations, even before there's a settlement offer, as negotiations move forward, you should keep your client informed of those negotiations and let them know what's happening. All of you, I'm sure, are familiar with needing to explain things in plain English to clients, particularly clients who may not be English speakers. So in that case, you would explain it to them in their language, but in non-legalese, non-technical, as much as you can, in language that is going to be accessible to them so that they can really understand it, just as you would explaining any kind of immigration relief or immigration procedure to a client. When it's a minor who that you're representing and a settlement offer has been made to the minor, at least in some states, in many states, there is a requirement that there be a formal approval of the settlement, a review and approval of the settlement on behalf of the minor. And that may be carried out, varies from state to state. It may be carried out by a court, may be carried out by some other entity. You really need to look at your state law to figure out what is involved for any kind of an approval when it's when you are representing a minor. And that would include even those minors that are over 14 years of age. So it would include anybody who's a minor under state law.
And it's also the kind of thing that you can call like a personal injury attorney or a tort lawyer who may have a sense, be able to direct you to what your state's requirements are. And so, because I think folks that practice that kind of law are definitely more familiar with how it works. Want to move to the next slide? Very briefly, we just wanted to give folks a sense of what that step 2 process would look like. If you are going to district court, if you're going within 6 months, if you've got a denial, you've got to go within 6 months, or if you want to treat the lack of agency action for a 6-month period as a constructive denial, then you can file in federal court. Damages claims under the Federal Tort Claims Act have historically been also filed with what we call Bivens claims. Bivens is a judicial remedy that allows for both monetary and punitive damages against an individual immigration officer for unconstitutional conduct. And sometimes when you have FTCA claims, you also have Bivens claims because of the officer's actions. And so people can sue both the officer and bring an FTCA claim. That is well beyond the scope of this webinar, although NILA does have a practice advisory on Bivens claims. One thing to just note is that you can only recover under the FTCA or Bivens. You can't recover under both. And so in the immigration arena, most people tend to bring those FTCA claims because the individual officers don't have the kind of money for compensation that the United States does or the agency does when you're bringing a claim under the Federal Tort Claims Act. In district court, the defendant is always and only the United States. That's set by statute. And you can bring your district court action either in the federal district court where the act or admission occurred, or where the plaintiff, the individual, resides. So there's two options there for venue. And once you get into filing a district court complaint, it is not uncommon for the government to move to dismiss, bringing up a variety of arguments like jurisdiction, this thing that's called the no private analog, where they will say that there is no federal actionable conduct that is actionable under the FTCA. There's no analogous tort, basically. And they'll also bring things like the discretionary function exception, that the officer was acting within his or her discretion or due care, they were following the law, all things like that, again, beyond the scope of this webinar, but they are discussed in more detail in our practice advisory. And so we want to make people aware of that. And before I turn it over to Mary for the last slide, I will just say that most FTCA claims, even in district court, settle out if you are successful in defeating a motion to dismiss. And so I just wanted to remind people that you're not necessarily signing up to go to trial. A lot of these cases are just decided on the papers. And I'll turn it over to Mary for the last slide.
So we wanted to make sure that you were aware of some resources that are available to help you with these claims. And the first is the FTCA packet that Trina has mentioned. It includes a checklist. It includes a sample or a filing checklist, so you make sure you get all the documents that need to be included in the packet. It includes a sample cover letter, the addresses for service of the claim for multiple immigration agencies, a sample claim authorization form, and a sample attachment, which is the narrative that has to be included with any claim. There's also a practice advisory on our website that we put out, NILA put out with the NIP, and our website is immigrationlitigation.org. So please feel free to look for that and use it. And then there's the technical assistance that Yasmin talked about at the beginning of the presentation. And then I want to just flag one other resource that you can take a look at, especially if you're bringing a claim against a CBP officer. And that's a website called Hold CBP Accountable. It's a website that Trina and I were involved in getting off the ground a number of years ago, and some other nonprofits are continuing it. And it's a great resource. It lists, it is updated regularly to include damages cases as well as other kinds of cases that are brought against CBP, including Border Patrol officers, based on misconduct of those officers. And so if you have a case involving a CBP officer, I think that would be extremely helpful. You'll probably find something that parallels the kind of conduct that you're looking at in your case. So that's it.